I'm Barbara Rhomberg. I'm very pleased to be here today. And I have a unique role here at the conference because I was asked not to look at federal constitutional law or campaign finance law, but rather to look at the idea of corporate personhood under other laws. If the Constitution were amended to provide that corporations were not people, would our concept of corporate personhood disappear? So I looked at 3 areas of law for this survey, and I looked at about 7 state laws in particular to see what they said. I looked at the authorizing statutes that create corporations, and I looked at all the rest of the state and federal laws that regulate behavior of corporations and all the rest of us, and I looked at state constitutions. Now, on the authorizing statutes, as was quoted here before, the Supreme Court has long held that corporations, being creatures of law, have only the powers that they are granted under the authority of legislatures. As long ago as 1804, the Supreme Court said the act of incorporation is, for them, speaking of corporations, an enabling act. It gives them all the powers they possess. And that view of corporations as having legislatively conferred powers has never really been questioned as a judicial matter. They're creatures of law. So what do these laws that authorize corporations say? Most corporations in the United States are created under state law. They're incorporated in one of the 50 states under laws enacted in that state to provide for the formation of business corporations and other kinds of corporations. Now, all state laws nowadays provide that corporations can be formed for any lawful business or any lawful purpose. And along with these broad purposes, corporations are generally given very broad powers. Several states and the Model Business Corporation Code, which is very influential, provide that a corporation has the same powers as an individual to do all the things necessary or convenient to carry out its business and affairs. And even states that don't use that phrasing, the powers of an individual, use the necessary and convenient part. So I think every state law I looked at says that a corporation has all the powers necessary and convenient to carry out its business, which can be anything lawful. Now, it wasn't always this way. In the early days of the United States, early incorporation statutes might have provided a corporation could only be formed for a specific purpose, like building a railroad or a canal. And then later, corporations could be formed for broader purposes, but the articles of incorporation that formed it had to say what the purpose was. And a corporation would be deemed to have all the powers given to it explicitly by statute and those implied by its purpose. So a corporation to build a canal would have the implied power to hire ditch diggers to dig the canal, because you couldn't build a canal without hiring people to dig the canal. But there was a lot of questions then. How far did those implied powers go? Did they have the powers to pay pensions to the ditch diggers? Did corporations have the powers to own stock in another corporation? Did they have the power to make charitable gifts? How did that help you build the canal? And there's even a few isolated cases about whether they had the power to make political contributions or engage in political spending, or if that was outside the powers of the corporation. Now, in the 1800s and early 1900s, this led to a lot of litigation in courts about whether acts were outside the powers of a corporation. It's called ultra vires. Was something within the powers of the corporation or not? And you'd have to look at the state statutes and also their articles of incorporation. And I think states sort of thought it was a nuisance because states have mostly gotten rid of that litigation about what's within the powers of the corporation. And they've done it partly by allowing corporations to be formed for any lawful purpose. They don't have to state what their purpose is, and providing very broadly that they have any power necessary or convenient to carry out that business. And whether something is necessary or convenient to carry out their business, if you as a shareholder, for example, go to court to challenge that, would be judged under a very differential business judgment rule. Did the corporate officers and directors reasonably think, and in their business judgment, it was going to advance the interests of the corporation? So nowadays, I don't think there's really any doubt that corporations have the power under their authorizing statutes to make political contributions if they can justify it as being necessary or convenient to carrying out their business purposes. So when you hear those sweeping languages about corporations being creatures of law, they have only the powers given to them by law, you might wonder, well, could we turn the clock back? Could we go back to the days and say, well, just change the laws. Corporations won't have the power to make political contributions anymore, and we'll solve the problem that way. I don't think that's really very practical because corporations are, for the most part, incorporated in the states. And the state laws that give them their powers and regulate what they are allowed as a legal entity to do are in the state level. They're judged under state law. So a Delaware corporation, its powers are judged under Delaware law. And if you form a corporation in California, it'd be judged under California law. And corporations can move, they can reincorporate, and where they're incorporated doesn't necessarily have anything to do with where they do their business. Most of the Fortune 500, or at least a goodly portion of it, is incorporated in Delaware. So I think it'd be very difficult to change the corporate powers at the state level, because Nevada is not going to pass a law that says its corporation can't engage in political spending, because they'd be afraid that all their corporations would take their charters and their franchise fees to Delaware, and Delaware isn't going to pass that law because they'd be afraid everyone would move back to Nevada. So there's been a lot of academic commentary among corporate law professors about how much competition there is among the states for corporate charters, but I think it's very unlikely you'd have any real political reform through changing their authorized powers. Now, this doesn't mean that states gave up on regulating corporations. They just don't do it by restricting their powers as a legal entity. They do it by making them subject to all the laws that regulate business and other behavior. So the second area I looked at was corporate personhood under all the rest of these laws. That laws at state and federal level that tell us what people are allowed to do and not allowed to do. And what I found is it's extremely, extremely common to define the term person as a corporation. The very first section of the United States Code states, let's see, in determining the meaning of any act of Congress, unless the context indicates otherwise, the word person and whoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. Having defined person to mean all these types of business entities, federal laws are commonly worded to control the behavior of persons or give rights to persons, even when the laws are primarily intended to affect businesses. For example, a federal law that's regulating mortgage origination and what you have to disclose when you're making a mortgage might expect that most of those mortgages are going to be given by businesses, but the law will define what persons have to do, what a person has to do. And that's the way the federal codes are drafted. It's also the case that most state laws are drafted that way. Several states I looked at are like the federal law, that there's one definition of person that covers the whole code. Delaware's like that. Texas is almost there. It has a single definition of person that applies to most of the laws. But even the state laws that don't have one definition of person covering the whole law, those laws are just peppered with definitions of person. When you search, you'll find dozens of instances in each state code if they don't have a general definition of person, saying for the purposes of this law or this section or this chapter of the law, person means a corporation and might go on to list partnerships, business trusts, limited liability companies, or other business entities. That's not the only way you could draft laws to cover corporations and other business entities. We could certainly think of other ways. We could say for every statute you wrote, you would say it's unlawful for a person, a corporation, a partnership, a trust, a limited liability company, association, or any other entity to do this. And it's unlawful for a person, a corporation, a limited liability company, a partnership to do that. That would be another way. Or you could define a term for an entity or something like that. We could draft the laws in other ways, but that's not how they are drafted. It's a very predominant drafting technique at both the state and federal level to define person to include a corporation. And one point I'd like to emphasize is these laws are defining person to include a corporation is generally not to empower the corporations. That is not the purpose of the definitions. The purpose is to make it crystal clear that corporations are subject to the laws, they have to obey them, and they can be penalized if they don't obey them in any manner the law allows. So corporate personhood in statutory law is as much as anything a technique of corporate control. It's a way to regulate businesses and make them subject to the same laws. And every business that's engaged in certain activities is subject to the same laws, whether it's an individual or a partnership or a corporation. Now, the last thing I looked at was state constitutions. Every state has a constitution, and I think every state constitution has some version of its own Bill of Rights or Declaration of Rights. Many of them are modeled, at least in part, on the Federal Bill of Rights and guarantee citizens of the state certain protections. Now, a state constitution can't trump federal law. Under the US Constitution, federal law is always supreme over state law, will always preempt a state law that conflicts. So a state level protection doesn't enable a corporation or any individual to escape the impact of a federal law, but it can have an impact on state laws. And all the state constitutions I looked at a few things. I looked at, do they have a free speech clause? And they all do. The wording varies from state to state somewhat, but every state constitution had a free speech clause. I looked at whether every state constitution had a due process clause, and they all did. Something that guaranteed persons or citizens, depending on the wording, due process. And I also looked at takings, whether there's a provision in the state constitution preventing taking of property without compensation, and they all had that. So turning back to that free speech area, state constitutions have free speech rights. Our Constitution in California has a free speech right. If the federal Constitution was amended so that corporations no longer had First Amendment rights under the federal Constitution, that wouldn't necessarily affect how our state free speech clause was interpreted. So corporations have been held in California actually to have some rights under the state free speech provision in the Constitution under a logic very much like the Bellotti case that was mentioned. It's not so much that the corporation has the right to say it, it's that people have the right to hear it and that society has an interest in the free flow of ideas. So how would that affect campaign finance at the state level? Now, if you look at state constitutional cases, it's very hard to tease out what are the rights under the state constitution and what are the rights under the federal constitution. Because if a court is considering both, there's a tendency to look most to the federal precedents, because if you can't pass a law under the federal constitution, then it doesn't matter whether the state court would allow it or not, right? If the state constitution would allow it. So if you take away that First Amendment protection from corporations under the federal constitution, I think we see a lot more litigation under the state constitutions. And a lot of the same kinds of decisions that have prevented campaign finance reform measures from taking effect at the federal level under federal constitutional principles might continue to affect whether states could enact campaign finance reform at the state level for state offices of the governor and the legislatures, and very crucially in states that elect judges, state judicial elections. So one thing to consider is if you want campaign finance reform that's going to be available at the state level, you have to also look at those state constitutional rights and what authority states would have to regulate campaign finance. Thank you very much.